5 seconds to go. Start. The present appeal challenges the final judgment and order dated 23rd January 2020 passed in criminal application 859 of 2019, wide which the learned division bench of the High Court of Judicature at Bombay at Aurangabad dismissed the application under section 482 of the Code of Criminal Procedure 1973 for quashing and setting aside the first information report number 339 of 2018 dated 6th November 2018 registered with Shivaji Nagar Police Station Latur for offences punishable under sections 498A, 312, 313 and 34 of the Indian Penal Code 1860 filed against the husband of the complainant Madhav Suryavanshi and the present appellants Digambar Suryavanshi, appellant number 1 and Kashi Bhai Suryavanshi, appellant number 2, parents-in-law of the complainant. Shorn of details, the facts leading up to the present appeal are as under. As per the FIR, the complainant and Madhav Suryavanshi, son of the appellants, were married on 26 March 2006. Two daughters were born out of the wedlock. After the birth of the second daughter in 2011, the complainant's husband and the appellants demanded a son from her. They berated her and insulted her and inflicted physical and mental cruelty, stating that she was giving birth to only daughters. Due to the ill treatment, she began residing separately from the month of February 2018. It was further alleged that the appellants used to instigate their son, husband of the complainant, against the complainant. He would beat her, citing the reason that she was not giving birth to a male child. It is further alleged in the FIR that on 28th November 2016, the appellants, along with the complainant's husband, visited her in Latur. The appellants asked the complainant to eat a meal prepared by them, which she refused to consume initially. However, they coerced her to eat it despite her protests. On the next day, she had stomach pain in the morning and she started bleeding. This led to her baby being aborted in her womb. On 5th December 2016, she visited the doctor along with her sisters and it was discovered that a piece of the fetus is still in her womb and she was treated for the same. Based on these facts alleging about the forced abortion and physical and mental cruelty, the complaint was made. The appellants, along with their son, filed a criminal application under Section 482 of the CRPC, praying for quashing and setting aside of the FIR number 339 of 2018 before the High Court. During its pendency, the family court at Latur, wide order dated 20th May 2019, granted a decree of divorce by mutual consent and dissolved the marriage between the complainant and the son of the appellants. The High Court, wide impugned judgment and final order dated 23rd January 2020, dismissed the application filed under Section 482 of CRPC for quashing of the FIR number 339 of 2018. Being aggrieved thereby, the present appeal was filed. Notice was issued by this court, wide order dated 2nd June 2020. During the pendency of the matter, the charge sheet came to be filed on 8th February 2021. We have heard Shri Shirish K. Deshpande, Learned Counsel for the Appellants, Shri Samrat Krishan Rao Sinde, Learned Counsel for Respondent number 1, State of Maharashtra, and Shrimati Prichiti Deshpande for Respondent number 2, Complainant. Shri Deshpande submits that the appellants before this court have no active role to play. They have merely been roped into the complaint as they are the parents-in-law of the complainant. It was further submitted that if such a serious offence was committed by the appellants on 28th November 2016, it should have been mentioned in the notice of divorce sent by the complainant on 15th May 2018, as it is alleged in the FIR that the son of the appellants had also allegedly played a role in that incident. There is not even a whisper of this incident in this notice. The complaint was filed after the notice of divorce, and it was merely filed to mount the pressure on the appellants and their son. This clearly shows that the complaint is concocted and it was filed as an afterthought only with an intent to take revenge on the appellants. Shri Deshpande further submitted that even if it is believed that the complainant allegedly found a piece of fetus in her womb after she was examined by the doctor, it does not automatically mean that some poisonous substance was given by the appellants to her, as there is not an iota of evidence to that effect. It was further submitted that since the appellants and their son did not succumb to the pressure applied through the complaint and did not favorably respond to the notice of divorce, another FIR was registered on 25th February 2019 against the son of the appellants for offences punishable under sections 307, 336 and 427 of the IPC, alleging that the son of the appellants had tried to kill her on the road in broad daylight. It was further submitted that these pressure tactics compelled the son of the appellants to cooperate with the complainant, and the divorce for mutual consent was granted on 20th May 2019 by the family court at Latur. It was further submitted by Shri Deshpande that after a bare reading of the allegations levelled in the FIR, they seem to be absurd and are inherently improbable. There is no circumstance where a conclusion can be reached that there is sufficient material to proceed against the appellants. Lastly, it was submitted that the contents of the charge sheet clearly reveal that the appellants herein had no role to play in the miscarriage suffered by the complainant. The doctor's statement reproduced in the charge sheet clearly states that the complainant had visited the hospital due to severe abdominal pain and bleeding. The doctor clearly stated that it was possible that the fetus became inanimate due to the abortion pills in the woman's diet, and that seems to be the reason for the excessive bleeding. No opinion was given as to when the pills were ingested and in what form were they ingested, and hence no role of the appellants herein could be established. Per contra, Shri Samrat Krishan Rao Sinde, Learned Counsel for Respondent number 1, State of Maharashtra, submitted that the allegations levelled in the FIR prima facie disclose the commission of offences under section 498A, 312, 313 and 34 of the IPC. The complainant was consistently harassed after the birth of the second daughter, as the appellants and their son wanted a male child, and therefore mental and physical cruelty was inflicted upon the complainant. It was further submitted by Shri Sinde that the appellants herein instigated their son against the complainant and played a major role in the harassment and the cruelty inflicted against the complainant. The appellants herein also played a role in the miscarriage suffered by the complainant. Stove.